I want to introduce our very esteemed panel. To my left in order is Jamie Harrison, who is the Deputy Director General of the LCIA, who will speak first. You've had online his and the other speakers' bios, so I'm not going to say anything more other than to mention that Jamie has come all the way from, is it the third floor to here? So he's had a long journey. Next to him is Ravi Aswani, a barrister, arbitrator and mediator at 36 Stone. And then finally, Robert Gay, an arbitrator at the far end. I've told every speaker that they have an absolute maximum of 20 minutes, and then the floor will open and they will disappear in a big hole. And that I hope takes us to about 7 o'clock, with then a short question and answers to follow. So that's all I wanted to say, and I'll invite Jamie to speak first. Thank you very much.
Thank you. I'm going to press start. Thank you. It's a pleasure to be here this evening. As Sir Bernard said, it's a very short journey for me, and real pleasure to have the opportunity to speak about a case which has been causing much comment, if not controversy, over the last few years. I appeared on a panel last week where the topic was fraud in international arbitration, and the barrister who'd appeared for the losing side in this case, one of the barristers, was on the same panel and described it as a, quote, bad judgment. He would say that, I guess, but I hope that you'll see that whether you disagree or not with the outcome, the judge did raise some issues which he hoped the arbitration community would debate and reflect on in just this sort of a setting. I was reminded earlier this week that given this is an open meeting and that the format is hybrid, so we have friends and colleagues joining us remotely from goodness knows where, that we don't fall under the Chatham House rule tonight. So given the LCIA's position as an independent, wholly impartial tribunal institution, I will do my best to explain what happened in the case and why it's given rise to so much interest, and I will try not to leave you too disappointed by sitting too neatly on the fence when it comes to offering you some views. That said, we have a relatively limited slot to deal with a case that's been going on for several years. So I have just set out for you what I would like to cover during the course of this presentation. Just to run through the timeline of the case, we're here to talk about a very lengthy 140-page judgment. I actually went to the trouble of printing it off earlier and reading it. It was handed down in October last year by Mr. Justice Knowles following a hearing last March. Nigeria successfully challenged an $11 billion arbitral award under Section 68(2)(g) of the Arbitration Act on the basis that the award had been obtained by fraud and the way in which it was obtained was contrary to public policy. A rare achievement, as you'll appreciate. These sort of applications are relatively rare and even more rarely successful. The facts of the case are complicated, but in very straightforward terms. Process and Industrial Developments Limited, which helpfully has almost uniformly been referred to as P&ID, not so easy to say, I have to say, P&ID, and the Nigerian Ministry for Petroleum Resources signed a 20-year gas supply and processing agreement known as the GSPA in 2010. I suspect that these contracts are rather more familiar to you than they are to me, but essentially Nigeria was to provide wet gas to gas processing facilities constructed by P&ID, who would process the gas into lean gas, which would in turn be delivered to Nigeria for power generation. The GSPA contained an arbitration clause with London as the seat of arbitration, and in 2012, P&ID filed for arbitration asserting the failure of Nigeria to meet its obligations under the GSPA and claiming lost profits. In July 2015, the tribunal found in its partial award that Nigeria had repudiated the contract by not supplying wet gas, and attempts by Nigeria in 2016 to set aside that partial award on liability were unsuccessful due to a lack of evidence. In 2017, a final award was rendered against Nigeria, finding it liable to P&ID in damages for $6.6 billion US dollars. By 2023, when the High Court rendered its judgment on the challenge application, the award had reached $11 billion by virtue of interest. P&ID started these enforcement proceedings of the final award in 2019. But meanwhile, Nigeria was making various applications for discovery against P&ID in various jurisdictions around the world, and in December 2019 applied to set aside the final award and to challenge enforcement based on the new evidence they'd uncovered that the GSBA itself had been procured by fraud. In 2020, Nigeria obtained what was described as an unprecedented extension of time from the English court under Section 70, subsection 3 of the Arbitration Act to apply to set aside the final award. Sir Ross Cranston decided that there was a strong prima facie case of fraud and that Nigeria had not made any deliberate decision not to investigate it. So that's the procedural background, which in itself is quite intriguing. And essentially, allegations of fraud were made by Nigeria, and they were extreme and numerous. That's unusual. It's not uncommon, as you all appreciate, for one party to raise allegations of fraud in the underlying agreement, but allegations about the way the defense of the case was conducted is unusual, to say the least. Nigeria alleged a number of frauds, that numerous civil servants, its internal legal team at the relevant ministry, and even its own counsel in the arbitration proceedings had been corrupted by P&ID, relying on a significant quantity of disclosure, which evidenced corruption in the negotiation of the GSPA. A certain number of bank statements seem to have been the most frequent document. P&ID's defense was technical, basically that irrespective of the corruption alleged by Nigeria, it had failed in the proceedings because of the failure of the relevant government ministries to properly participate in the arbitration on the one hand, and the incompetence of its counsel on the other, which they argued was not grounds to set aside the award. Due to lack of evidence, the court was unable to make findings of fraud on some of these grounds, but the judge was satisfied that P&ID had paid bribes to a former legal director at the Ministry of Petroleum Resources and a lawyer involved in the drafting and negotiation of the GSBA on behalf of Nigeria, and that P&ID had put forward witness evidence that concealed the fact. The relevant director was also receiving ongoing bribes to ensure her silence throughout the course of the proceedings. And secondly, had improperly retained and misused Nigeria's privileged and confidential legal documents, which had allowed it to know whether its corruption of the director had been discovered by Nigeria. And the court therefore found a serious irregularity under Section 68G of the Arbitration Act, and that the award should be set aside. Just while we are looking at the extreme things that happen in this case, it's also worth going back to the extension of time for Nigeria to commence its application to set aside the award, which had been granted by Mr. Justice Ross Cranston in 2019, by which Nigeria obtained an extension of around 2.5 years. This does seem extraordinarily generous, given that the Arbitration Act allows you 28 days in normal circumstances. However, these were extreme circumstances. The judge, during the application to set aside the award, also considered Section 73(1) of the Arbitration Act, which deals with the loss of the right to object. I've put it up there, so you're quite capable of reading it, and it's in your notes. But clearly, the judge was persuaded that in the circumstances, the loss of the right to object didn't apply. He said, even if I take them together, I do consider that the points show that reasonable diligence required Nigeria to look for bribery in this case. There were many other things specifically identified to look into. What matters is whether reasonable diligence required Nigeria to look for bribery whilst dishonest evidence further concealed it. And he decided that it didn't. So that was really the main part of the judgment. And what's really given rise to a significant amount of discussion and comment since the judgment was handed down are the famous last words, this. The fact that, generally speaking, I think the commentaries tend to conclude that the judge was pretty much correct on the substantive issues that he had to deal with. But he then, at the end of the judgment, it's 4 or 5 pages at the end, offers some reflections, points of reflection, which he invites groups like ours to reflect on and to debate, which have given rise to quite a lot of comment, not least as to whether that was rather overreaching what he was there to do. But nevertheless, this is a case where substantial fraud and corruption went seemingly unchecked and undetected during the arbitration process. And I think that has heightened concerns about transparency and reliability of the arbitration process. And the judge did comment that P&ID had practiced the most severe abuses of the arbitral process and was very concerned that this should not happen again. The areas that he asked us to reflect on, and I'm sure that you, if you haven't done already, you will do, and it will probably give rise to some debate later. But the issues that he particularly raised, the first was on transparency. The case provoked a lot of discussion about arbitrations involving states, or to some extent SOEs, but states in particular, and whether those cases ought to attract greater transparency and visibility. Of course, commercial parties often choose arbitration for the very reason that those proceedings are confidential. But privacy in this case meant, of course, that public scrutiny of what was going on and what wasn't being done was completely absent. And it is arguable, of course, that in those sort of cases, particularly where a great amount of public money is being spent, that perhaps proceedings should be a little more open than they are currently. Transparency provisions in investor-state arbitrations at ICSID do recognise the importance of accountability and public oversight in cases of public interest, especially where states are involved in high-value contracts. And since 2019, there has been a presumption that ICC awards will be published, albeit with the permission of the parties who may require anonymisation. I think it seems unlikely that similar transparency provisions will apply in national arbitration laws. We seem to have missed the boat for the UK for this round at least. But perhaps states should encourage the incorporation of transparency provisions and protocols in their arbitration agreements. From the LCIA's perspective, I think it's unlikely that we will develop special rules for states or SOEs participating in arbitrations administered by us. It has been suggested, and even that this should be the default unless states or SOEs opt out of them. It's not really the LCIA's style to bring in separate sets of rules for particular issues or particular sectors. And as I say, we're unlikely to do that. We believe that the LCIA rules themselves are strong enough and they give the arbitrators plenty of opportunity to administer the case strongly and properly. It is also worth noting that in 2023, out of, I think, 370 new cases registered by the LCIA in 2023, 55 involved SOEs, but only 4 involved a state. So the idea that we would produce special rules is, I think, unlikely. Disclosure, document production was clearly very significant in this case. Crucial information about bribery and corruption was only uncovered as the result of applications made internationally to courts as late as 2022. And the judge was preoccupied really about the importance of disclosure in arbitration proceedings. Of course, had the arbitrators had greater powers to compel document production, given the way that P&ID had behaved, there's no guarantee that they would actually have produced those documents. But it was a key issue in the case. It is often argued that the powers of tribunals like those that sat in this case are quite limited and could be improved perhaps by increasing the powers to sanction parties for non-production and to encourage closer cooperation with national courts to obtain and to enforce appropriate orders. Tribunals also need to, I think, be backed up by standard ethical obligations applicable to counsel from all jurisdictions. Valuable soft guidelines do exist. The IBA guidelines of 2013 on representation are a good example, but perhaps they could do with a review and an update. You should also look at the annex to the LCIA rules, which are general guidelines for authorised representatives of the parties. They seek to promote the good and equal conduct of authorised representatives of the parties appearing in an arbitration. And I'd invite you to look particularly at paragraphs 3, 4, and 5. Generally, there's a concern, I think, that sometimes limited or certainly different professional ethical standards apply in different jurisdictions. Some lawyers just do things differently. We often point to preparation of witnesses for cross-examination in some jurisdictions and not in others, notably in our own. So perhaps we need a proactive discussion at an early stage about the ethical standards expected in the proceedings. The judge also spoke about the balance of power. He spoke about the complete imbalance of the parties' contributions to the drafting of the GSPA. I mean, on one view, the complete imbalance was caused by the fraud perpetrated by one of the parties in those negotiations. But there was certainly an imbalance in the experience and resources between the two parties. And of course, we should always have an eye on that. Perhaps the issue that's caused the greatest comment is that as to whether the tribunal should have been more direct and interventionist, where legal representatives have failed to perform to the standards required of them. The judge noted that in this case, even without P&ID's fraud, Nigeria had been compromised by its counsel's failure to put forward the required legal and factual arguments and to deal with certain issues and documents with witnesses. I think this rose primarily from poor instructions given by the Nigerian government client, but there were certainly failures on the part of the legal representatives, experts, and politicians and civil servants behind the scenes who had put Nigeria at a serious disadvantage compared to the very well-resourced team put forward by P&ID. But the judge did find that as a result, the tribunal didn't have the assistance that it was entitled to expect and which makes the arbitration process work. I think it's safe to say that the legal background of the members of the tribunal and the law of the seat and the governing law, etc., of the underlying contract will all have a bearing on the approach the tribunal takes. But I think it's not been lost on the commentators that this was a tribunal seated in England and chaired by a former Court of Appeal judge. And it was very unlikely in those circumstances that there would be great intervention from the tribunal during the course of the proceedings. But what should we expect of tribunals in these circumstances? Should the tribunal interfere if it is clear that there's a lack of instructions or poor instructions, such as a failure to test an expert's opinions, leading to a compromised presentation of the case? The LCIA rules, Article 22.13, notes the ability of the tribunal to conduct such inquiries as may appear to the arbitral tribunal to be necessary or expedient. And Article 25.1 of the ICC rules has a similar provision noting the tribunal's duty to establish the facts of the case by all appropriate means. It's a thorny issue, which requires the arbitrators to tread a very fine line between ensuring a fair fight on the one hand, and that they respect their need to be fair and impartial, and to allow each party to put its case, the central tenet expressed in Section 33 of the Arbitration Act and reflected in Article 14 of the LCIA rules. Whilst arbitrators are not barred from asking a party whether it's considered raising a different case from that which it's advanced, Section 33 doesn't oblige them to do so. We should also note there are a few other considerations weighing on the tribunal, and in particular, the obligation on the tribunal to avoid any unnecessary delay. And of course, this was a case where there had been extraordinary delays all the way through. The facts of the case are quite special, and the judge did point out there were a number of red flags which should have alerted the parties and the tribunal about the fact that something was going on and that Nigeria was at a material disadvantage. And a particular one that was noted was the failure of Nigeria's counsel to cross-examine properly P&ID's witnesses dealing with quantum. Anecdotally, at a recent LCIA symposium, we discussed the question of how far the tribunal should go when intervening in these kind of situations. And the conclusion was that in the general course of the proceedings, not too much. It's not for the tribunal to lead a party to its best case, but it is okay to invite a party or both parties to consider a point that was not well made or a case that was not referred to, but not much further. However, perhaps on issues of quantum, especially where the numbers are huge and public money is involved, that the tribunal should consider taking a more proactive role. And after a fairly quick rattle through, really the million-dollar question, what now for international arbitration? I guess that's something we can talk about in questions, but from my perspective, even taking into account Nigeria's inordinate delay, I think it's hard not to understand the sympathy the court had with its position, especially given the huge sum involved, 11 billion US dollars to pay. The court's willingness to do justice to Nigeria's case may lead to unintended consequences in other cases, which would be less desirable and perhaps would be the thing that the LCIA would try and resist. Parties which have lost in arbitration but are desperate to avoid complying with the terms of an adverse award may be encouraged to go to greater and greater lengths to seek out ways to challenge unfavourable awards, even if, as in this case, the grounds are not discovered until many years after the proceedings have concluded. And then arbitration awards may not be quite as final as we had all thought. And that's all I have to say.
Thank you, Jamie. We'll come back to some interesting points at the end, and I'd now like to ask Ravi to speak. I should have said right at the beginning, I hope you all have the handouts, and I should have thanked Gerard, which I didn't do, for doing all of this, and I should have thanked 36 Stone as well for sponsoring this event as well. So I hope you've all got your sheets. If anyone doesn't have one, there we are. There are some at the back. Right, Ravi.
Thank you. Good evening, everybody. I'm going to speak about three separate cases, all involving one common party, RusChemAlliance. And I've identified them in my presentation. The first one I'm going to call Deutsche Bank for sake of convenience. This went to the Court of Appeal, and the references are there for you. The second one I'm going to call UniCredit, and this one also went to the Court of Appeal, although there is news the Supreme Court is going to consider this on the 17th and the 18th of April. And so that is likely to be, at least from the courts, the last word on this particular set of issues. And the third case, Commerce Bank, I don't need to say too much about that. This only went to first instance. There's no appeal that I'm aware of in that particular case. As I've said here, there is a common factual background in each case, but before going on to that, I thought it might assist to set the context, just to remind everyone of what the Supreme Court decided in Enka and Chubb. Those of you who've looked at this will recall that there were, over a period of years, some interesting authorities which didn't necessarily all point in the same direction as to the identification of the law applicable to an arbitration agreement. That has now been resolved by the Supreme Court in Enka and Chubb, and it's paragraph 170 of the judgment, if anyone wants to look, in which their lordships set out 9 applicable principles. The one which particularly was engaged in this case was this one, and it was number 4, where there is no express choice of law for the arbitration agreement, which frankly, as 100% of contracts I've ever seen, I've never seen a party expressly choose a law for the arbitration agreement. But there is a choice of law for the main contract, then the normal inference will be that that choice for the main contract will also apply to the arbitration agreement. That inference can be displaced in certain circumstances, but that's the starting point. By way of footnote, we're at a certain moment in time where this is all going to be overtaken anyway, because the Law Commission's proposal, which will, we think, be enacted in the Arbitration Act 2024, is to move to a default rule that the law of the seat not the law applicable to the main contract, governs the law of the arbitration agreement. It may be that we get into a bit more of that in the Q&A, but that's all I wanted to say for now. The second reminder, just in case anyone hasn't looked at this recently, is that this is all about jurisdiction over foreign parties, which requires service upon them to bring them within the jurisdiction of the English court. And that, of course, requires a serious issue to be tried on the merits, a good arguable case of falling within a relevant jurisdictional gateway, and then England being the proper place to bring that claim. And the issues in this case related to the jurisdictional gateway and whether England was the proper place. There was no real issue about something to be tried on the merits. Now, as we know, in circumstances where a party is said to be in breach of an arbitration agreement, the English court will readily grant anti-suit injunction relief to restrain that breach. But what was novel about these cases was that the arbitration seat was not England. In all the cases where this point has come up beforehand, it's the English courts acting in a capacity as the supervisory courts of the seat, whereas that wasn't the case in this trilogy, and that's why it gives rise to some interesting issues. So with those reminders in mind, let's look at these cases. They were engineering, procurement and construction contracts on quite a massive scale, actually. If you look at the judgments, you'll see figures in the hundreds of millions. So a very massive project. And as is common in such cases, there were various advance payments and various bonds and guarantees guaranteeing refund of the advance payment and also other obligations. Now, those securities were all governed by English law, but provided for ICC arbitration in Paris. And of course, when I say governed by English law, I mean the main contract, the substantive bonds and guarantees themselves, not the arbitration agreement, which was not the subject of an express choice of law. What happened was events in Ukraine led to sanctions being imposed, and that led to suspension of work on the projects. In each of the three cases, RusChemAlliance wanted to terminate the contracts and required return of advance payment and damages and made various calls under the securities. And it's the calls under the securities which we're interested in. The various banks said, no, sanctions prohibit us from making this payment under the bond or the guarantee, as it may have been. And so what happened was RusChemAlliance will all have seen this in different cases. They commenced proceedings in the Russian arbitrators courts. And some of you may have seen this. There's an article in the Russian Arbitration Procedural Code, Article 248, which effectively grants the Russian courts exclusive jurisdiction and renders arbitration agreements unenforceable as a result of sanctions. There's a lot more that I could say on that, but it's just for background for our cases. Now, all the banks in our cases applied for anti-suit injunctions from the English court, and they needed permission to serve out, of course. This was the slight sticking point. CPR 62.5 was not available. The seat wasn't in England. Section 44 couldn't be used. There is some debate on this in the judgments, but it's pretty clear now that where we're talking about anti-suit injunctions, even in an arbitration context, the source of the English court's jurisdiction is Section 37 of the Senior Courts Act and not Section 44 of the Arbitration Act. For example, you can look at the Supreme Court's decision in AES Kamenogorsk for that. The first decision, Deutsche Bank, this came before Mr. Justice Bright on the 21st of August of last year, was a without notice application, which he did not grant. It's interesting, the judgment was anonymized at first instance, so there was no identification of the parties or of Russia, but there was enough in the judgment, as you'll imagine, to give rise to fervent speculation as to what might have been happening. This is the very interesting point. There was no evidence before the judge in that case explaining why the application hadn't been made in France. And the reason that was a relevant query was, of course, France was the court of the seat. And so logically, one might think that's where the application should be brought. Nevertheless, Mr. Justice Bright continued. He actually adjourned the hearing so that evidence on this topic could be produced overnight. And he reached the uncontroversial view that had this been an English-seated arbitration, he would have been very likely to have granted an anti-suit. So where did the fact that the arbitration was seated elsewhere leave the analysis? He was satisfied, applying Enker and Chubb, that the choice of English law in the substantive contract amounted to the law of the arbitration agreement, also being English law. And we'll come back to that shortly. He referred at paragraph 36 to the fact that the seat is outside the jurisdiction can, in a particular case, give rise to an exceptional circumstance militating against granting anti-suit relief. And he did mention in this paragraph 36, he thought it was unlikely that any of the senior judges in the Angelic Grace or Ust, Kamenogorsk, or indeed Enker had a foreign seat in mind when they said what they did. He may or may not be right about that, we just don't know. But certainly the facts were unique. The evidence before him, which, as I've said, there appeared to have been hastily convened overnight rather than being presented in an orderly fashion, was, we are told, that French law had a philosophical objection to anti-suit injunctions, and it might well, in its capacity as a court of the seat, grant an anti-suit in response if the English court did this. And this is what he said at paragraph 97. In some countries, ASIs are readily available to support arbitration. In others, they are not. Each country is free to form its own policy on this point. Similarly, contracting parties are free to arbitrate where they like. If the parties choose to arbitrate in a country such as France, where the policy is that ASI will not be granted and will not generally be enforced, this court should acknowledge the significance of these circumstances. Vive la différence. As will be seen, I have to say I've got some sympathy for that view. This is not something that has come on parties totally without warning, especially sophisticated parties involved in transactions of this size. But be that as it may, the Court of Appeal took a different view. The appeal was allowed and the anti-suit injunction was granted. For reasons which are not explained anywhere, at this stage anonymity was dropped and Russia was clearly identified. The difference was that there was further improved evidence about French law, which was very different to the evidence, the limited evidence that Mr. Justice Bright had. And this evidence was now to the effect that the French court would recognize the grant of foreign courts anti-suit relief, subject to considerations of public policy, of course. So the Court of Appeal thought we are obliged to reconsider this question ourselves now. And there were two questions, really. Firstly, was England the proper place to bring the claim? Yes, there was a serious issue to be tried, that much was clear. And there was a good arguable case in relation to the jurisdictional gateway, because the Court of Appeal too took the view that it was English law governing the arbitration agreement. Really, it's forum convenience type considerations. And it's interesting, reference was made all the way back to something Lord Gough said in the Spiliada about identifying the forum in which the case can be suitably tried for the interests of all parties and for the ends of justice. At paragraph 38, the Court of Appeal went on to say the ends of justice include the policy that parties should stick to their contracts. The French court couldn't do it, so the choice is either the English court doing it or it not being done, i.e. nobody granting an anti-suit. And for those reasons, the Court of Appeal thought clearly the English court is the proper place. And on the question of discretion, there was no reason not to grant it. In parallel to this was the UniCredit case. This was a decision of Mr. Justice Knowles, who, without notice, granted an interim anti-suit injunction and listed a return date. The return date came before Sir Nigel Tier, sitting in the commercial court. And interestingly, he said the content of French law was clear, not in dispute. There you can see in paragraph 23, he identified the question in relation to Enker and Chubb. And for the reasons I've mentioned at paragraph 24 and 25, he said that English law was not the law governing the arbitration agreement. The fourth principle from Enka in Chubb was something which was prima facie the position, but the inference wasn't warranted in this particular case because of these particular features of France being the seat and French law, which the parties would have had in mind. In any event, he said, it couldn't be said that substantial justice could not be done in France just because an anti-suit injunction wasn't available. He made the point at paragraph 37 that damages for breach of the arbitration agreement would be available in French law, in the French arbitration. And at paragraph 42, he emphasized the French arbitration tribunal would also seek to enforce the parties' bargain, just as the English court would. Interestingly, he had the Court of Appeal's decision in Deutsche Bank available to him, but he said that that was an ex parte appeal with no presence or submissions by the respondent. And to be fair to him, it seems what happened was he didn't have the full judgment available, more a sort of summary of reasons which the Court of Appeal may have given immediately to hold the position before issuing the judgment proper. Nevertheless, he did take a pragmatic approach and maintained the anti-suit injunction, which Mr. Justice Knowles had ordered, pending consideration of an application for permission to appeal. Court of Appeal granted permission and in fact, granted the appeal, as we'll see now. So the appeal was allowed by the Court of Appeal, no stay on the order pending any further appeal to the Supreme Court, which, as we now know, is going to be on the 17th and 18th of April. Some cooperation by the Russian judiciary, which may be thought to be surprising in the circumstances, but they did suspend the proceedings in the Russian arbitrage court until this appeal was dealt with. And interestingly, the claim at this stage was now one for a final, not an interim anti-suit injunction. So really, the Court of Appeal dealt with the point on its merits, not just a question of jurisdictional thresholds. The negative obligation inherent in an arbitration clause was not within the choice of law clause within the main contract. Okay. But you can see, I won't read it out. This is what they thought at paragraph 63. Which was actually in quite marked contrast to the approach of Sir Nigel Tier, as you'll immediately glean. So having established that it was English law and not French law applicable, was England the proper place in which to bring the claim? Court of Appeal on this really agreed with the approach in Deutsche Bank, which I've already mentioned. They did say quite pointedly, the suggestion that substantial justice could be obtained in France, whether in court or in arbitration, is an illusion. In the circumstances, a final anti-suit injunction was justified. The final case is a decision of Mr. Justice Bryan, which, as I've said, has seemingly not been appealed. This was without notice as well. There isn't as much of a dissection of the analysis of the law applicable to the arbitration agreement in this particular case. He did make the point, which is a common pattern now, but for the complication of the seat being in France, this really would be an archetypal case for an anti-suit injunction. Only one available avenue of redress, and that was anti-suit injunction relief from the English court. He made the point that the evidence before Mr. Justice Bright was quite limited, and Mr. Justice Bright had himself granted permission to appeal. The seat was of no more than very limited relevance under Section 37, which is interesting. And even if the law of the seat had some prominence, however, Mr. Justice Bryan thought that on the evidence there was no conflict capable of amounting to an exceptional circumstance. So where do we go from here? Well, the Supreme Court's decision in UniCredit will be the last word. I say the last word, it will be the last word we hear from the judges. It may be possible that you can obtain anti-suit injunction relief from the English court for a foreign-seated arbitration if jurisdiction can be established and England is the proper forum. This will always be a fact-specific inquiry, of course. If the position is that the courts of the foreign seat could grant such relief, but have declined or haven't been asked, or would consider a foreign order to be an interference on their procedure, that may put pay to the English court, trampling on that foreign court's toes. And interestingly, as we've seen from this trilogy, decisions might actually turn on the quality of the evidence of foreign law and procedure which are made available. Be a very interesting question to know why this was not dealt with in an orderly fashion before Mr. Justice Bright, but for whatever reason, it wasn't. As I've already alluded to, the arbitration bill, when it becomes the Arbitration Act, will establish a new law of the seat default rule that will modify the current ENCA and CHUB position. But going back to something I said at the beginning, parties will still, as they've always been able to, make an express choice of law applicable to the arbitration agreement. Why, oh why, I'm frequently asking my in-house lawyer colleagues, is this not done? It would really put pay to all of this, but for whatever reason it isn't. So that's a whistle-stop tour through those cases, and after Robert has spoken, we'll take some questions. We'll be happy to. Thank you.
Right, thank you very, very much, Ravi. A tangle of cases, and we await in the next few weeks decision as to, I'm not sure whether we might take a vote as to who's going to win in the Supreme Court. Maybe. Are you doing the case? I've forgotten. No, no, you're not doing it. All right. Right, Robert Gay, thank you so much. Thank you.
So, ladies and gentlemen, I need to begin with an apology in that if you were reading the publicity beforehand, you may have been expecting me to talk also about RusChemAlliance. But when I came to prepare for this, I found that Family Mart was much more complicated than I remembered, and that I had no chance even of saying everything about Family Mart within my allotted time. So if those of you who are physically present look at the back of the handout, you will find some slides in which I talk about RusChemAlliance and try to say why I agree with Mr. Aswani that there's a degree of sympathy for the approach of Mr. Justice Bright. But you're not going to hear any of that this evening. You're only going to hear about Family Mart. Now, Family Mart is a Privy Council judgment on an appeal from the Cayman Islands, but it's important to remember that it's one of an exact pair with a judgment of the UK Supreme Court called Republic of Mozambique and Privinvest. Now, I'm not going to try to take you through the facts or all the issues in the case that I'll call just Mozambique, because the crucial issue depends partly on Swiss arbitration law, and Swiss arbitration law is doing my head in. But it is important that it's a pair. They're handed down on the same day. In both, the only speaking judgment is by Lord Hodge. And if you think there's a puzzle about the priority in the strict law of precedent between the English Court of Appeal and a Privy Council judgment from the Cayman Islands, you may want to notice that Lord Hodge in Mozambique in the Supreme Court refers to Lord Hodge in the Privy Council in Family Mart, and very surprisingly, he approves of what he says in Family Mart. So this is going to change English law. Now, here are the facts. The company, whose name is entirely unmemorable, operates a chain of supermarkets in China. And it's a joint venture between mainland Chinese interests who know China but don't know supermarkets, and Taiwanese or Japanese interests who know supermarkets but have no foothold in China. And there is a shareholders agreement between the vehicle of the mainland Chinese interests, which is called Ting Chuan, and the vehicle of the Japanese and Taiwanese interests, which is called Family Mart China Holdings and is going to be referred to as FMCH. The way the joint venture works is a shareholders agreement, but in the shares in the company that runs the supermarkets in China, the Chinese interests have the majority of the shares and a 4-3 majority on the board of directors. And the shareholders agreement has an arbitration clause for ICC arbitration in Beijing. And not in one might well guess that the Japanese or Taiwanese interests are not wild about arbitrating in Beijing, in particular because if you read the whole judgment, there's already been one arbitration in Beijing, which they won. What's happening is Family Mart China Holdings alleges that the 4-3 majority of the directors are making contracts with other companies that belong to the same Chinese interests and are making them on terms which divert the profits of the supermarket into the hands of the Chinese interests. And they say this is a breach of the shareholders' agreement. And they go on to say that they've lost trust and confidence. There's been an irretrievable breakdown of the marriage, and they want to be able to buy out Ting Chuan. Now, under Cayman Islands law, for reasons we're not told, and it may just be accident, your route to a buyout is by way of a petition for the company to be wound up under the just and equitable ground that it's overall a good idea to wind it up. And it's only if you can persuade the judge that he would be minded to wind it up on that ground that in the alternative, the judge can make an order for the buyout. So the Family Mart starts this proceedings, and in response, the Chinese seek a stay to the arbitration in Beijing. And the immediate issue before the Privy Council is the effect of the fact that the actual court proceedings are at least formally directed towards a winding up of the company. And at least one of the issues is arbitrability. Now, I think the best way of understanding this, I expect almost all of you know very well what's meant by arbitrability, but for anybody who wants an illustration, the best illustration is given by the facts of a Singapore case called Mittal and Westbridge, which tells us that under Indian law, these allegations between shareholders of mismanagement or oppression can only be dealt with by an Indian company law tribunal. And if you have a foreign arbitration agreement and manage to get the foreign arbitrators to make an order reflecting a judgment that there's been mismanagement or oppression of this sort, then the Indian court will not recognize it, it will not give effect to it. You can't affect an Indian company otherwise than by going through the tribunal in Mumbai. And we can pause briefly and reflect on the likely political reasons for this in India. But under English law or Cayman Islands law, the basic principle about arbitrability is everything is arbitrable unless, and that is, and this is a quote from Lord Hodge, oh no, it's a quote from the Cayman Islands statute, unless the agreement is contrary to the public policy of the islands, or there is a rule of law or statutory provision that makes it non-arbitrable. So, as it were, the presumption is that everything is arbitrable, and under English law, there are mostly in favor of the small person, types of case that can't be compulsorily referred to arbitration. Employment law rights, rights under the Equalities Act, we'll come on to some sorts of consumer rights later. But on the whole, before Family Mart, I would have said there are very few or no claims that under English law have been made non-arbitrable by public policy as distinct from statute. Now, the Family Mart has an easy part and then a difficult part. And I'll try to take you through the easy part first and in straightforward terms before I start making your minds bend with the difficult part. What Lord Hodge says can't be referred to arbitration and there can't be any stay of the court proceedings is in relation to the actual decision to wind up the company and also in relation to the judgment that the court might make that it would be just and equitable to wind up the company. So the last step in Family Mart's Cayman Islands proceedings can't be taken by an arbitrator. An arbitrator can't make the just and equitable judgment that leads in Cayman Islands law to the possibility of the buyout order. What can be referred to arbitration and will be compulsorily stayed is the underlying questions, not just of fact as to whether the directors have been diverting the profits of the company, but also the question of law or mixed fact and law, whether they've been doing it as a frolic of their own, or whether this is a breach of the shareholders' agreement by the Chinese party. And also the questions of what you might call commercial judgment, whether an honest commercial person would look on this as just contracting with people who we know will be reliable counterparties and paying them a small premium because we know they'll be reliable companies, or whether it really is a diversion of profits. And of course, everything can be stayed if the whole claim is straightforwardly something that can be dealt with by arbitrators. Now, this tidies up some bits of English law, in particular in relation to winding up proceedings on companies, and it changes what was previously Court of Appeal authority. But I've put it in the handout in very small print because it's very detailed and not of interest to shipping lawyers. Before I go further, I'd like to pause a moment and say, I said there was very few cases where under English law, something was not capable of being arbitrated as a matter of public policy. There's an exception and a possible exception that are fairly new and which I'd like to mention. The exception is this case called Soleimani and Nifty Gateway, which from here on I'll call Nifty Gateway because it's a memorable name. And this is a case about a contract that was made by clicking a mouse. And Soleimani has agreed a New York arbitration agreement and also, incidentally, a choice of the domestic law of New York without regard to any conflicts of laws. And when Nifty Gateway sues Soleimani for $600,000, give or take, Soleimani says, okay, I made this contract, but I'm a consumer under UK consumer law, pretty odd consumer, but a consumer. And he says the arbitration agreement is unfair in terms of UK consumer law. And so under UK consumer law, it's not valid. And in the normal way, and the first instance judge did this, it would be stayed for the New York arbitrator to deal with, because there's no doubt that Soleimani has made an arbitration agreement. The question is whether the arbitration agreement which he's made is null and void. And in the normal way, that would be sent off to New York to be arbitrated. But in this case, the Court of Appeal directs a trial of issues, including whether he's a consumer and whether the arbitration agreement is unfair in terms of UK consumer protection law. They state at the end of the judgment 3 reasons, and the one that to me matters is number 2, which says arbitration is private and it's in the interests of consumers generally to have publicly available precedents as to the interpretation of consumer protection law. It's in the interests of consumers generally to know what are the factors that decide whether Soleimani counts as a consumer or not. It's in the interests of them to know whether the arbitration agreement counts as unfair and gets set aside or not. And so as a matter of public interest, this should not be sent off to the New York arbitrator to deal with in private. Now, it's not a decision as to non-arbitrability. Officially, this is just a case management decision. It's an exercise of the court's discretion whether to stay to arbitration or not. But it is noticeable as a decision not to refer something to arbitration made on public interest grounds. The other possible exception arises from a case which Lord Hodge cites in Family Mart, but doesn't expressly approve of or disapprove of, a Singapore case called Larsen Oil, where the Singapore court held that an arbitration agreement made before a company goes into liquidation cannot, as a matter of public policy, send off to arbitration claims that might be made by a liquidator after the winding up has started in terms of preferences, transactions again at undervalues and so forth. And previously, there are English authorities, or at least one, I think there's more than one, but I've only just found one, which said that's not English law. Under English law, an arbitration agreement made before the company enters into liquidation applies to these remedies by the liquidator. But Lord Hodge refers to the Singapore case with no sign at all of disapproval. And I think there might be at least another attempt to make Larsen Oil be part of English law. Now, before I go on to the difficult bit, for discussion afterwards, a couple of possible applications of the easy bit of Family Mart, by which the issues get stayed to arbitration, whereas the remedy is left for the court. Suppose there's an arbitration agreement between P and D, and instead of starting any ordinary sort of court proceedings, P decides the thing to do is to bring a private prosecution against D. Can the issues of fact in a private prosecution be sent off to arbitration, presumably for the arbitrator to decide whether he's satisfied on the criminal standard of proof beyond all reasonable doubt? And then the case just comes back to the court because the arbitrator can't send D to prison or fine D, so it has to come back to the court for sentence. And the other one for your entertainment is, suppose the Atlantic Confidence is facts, but there's an arbitration agreement between the ship owner in the bills of lading, which is binding on the cargo interests. So when the ship owner applies to it for a limitation decree, and the cargo interests appear and say, no, the ship was scuttled, he's not entitled to limitation, does that issue get sent off to arbitration? And at the end of the arbitration, the judge is left to make the decree of limitation or not, according to the arbitrator's findings of fact. Right, now, and quite quick because I'm short of time, the difficult part. The wording, and I think this is standard wording, not just in the Cayman Islands, but in England and elsewhere, is in respect of a matter that's to be referred to arbitration. And Lord Hodge tells us a lot about what counts as, quotes, a matter. And it starts off relatively straightforwardly. It's a reasonably substantial issue, and there can be more than one of them in the legal proceedings, and the legal proceedings can be partially stayed. Stayed in respect of one matter, but another matter remains in court, and it's a matter for the court's discretion whether to wait for the arbitrators or whether to carry on with the parts that are left with the court. And a matter is not something that is, quote, peripheral or tangential, and we'll come back to that in one moment. Remembering that the application for a stay is made before a defence, you need to look at predictable defences, and you need not just to look at how the statement of claim was written. But it seems to me that Family Mart changes English law, or at least changes what I thought was English law, in two respects. First, what Lord Hodge does with it mustn't be peripheral or tangential is to say it needs to be, quotes, legally relevant. And that means the issue needs to be part of the claim or part of an arguable defense. And it's not, you can't get a stay in respect of something that's just a matter of evidence. In the Mozambique case, the case was, surprise, surprise, about large-scale bribery resulting in large-scale contracts made by the Republic of Mozambique with some shadowy entity called Privinvest. And the question before the courts boiled down to whether there had to be a stay in respect of the question whether under the contracts the Republic received something worthwhile or just rubbish. And Lord Hodge says, you don't need to stay that because it's only a piece of evidence. It's not in itself a defense or essential part of the claim. So, and the other one is, you can't get a stay if your application for a stay is an abusive process. And it's going to count, according to Lord Hodge, as an abusive process if you have, quotes, no real or proper purpose for seeking the stay. So you can't make one application for a stay and then lose the arbitration and then apply again. Lord Hodge says in a Scottish voice, the court would be entitled to look with some care at the second application. And you can't get a stay if the issue is going to be dealt with in court anyway. And you can't get a stay if you don't really believe your own case. And that, my idea was that a stay, a referral to arbitration was a contractual right. And under English law, you didn't have to exercise your contractual rights in good faith or for a proper purpose. And I think by the back door, this is the Supreme Court and it changes the law. And I've just finished in time.
Thank you very much. Thank you very much, Robert. A real kind of overview of different areas. I would happily like to ask some questions myself, but is there anyone who would like to ask some questions? Mike is here. Mike is here. Any questions? Right, well, let me stir the pot a bit. If you haven't read the last, I don't know, 2-3 pages of the judgment of Mr. Justice Robin Knowles that Jamie was talking about, they are absolutely fundamental reading requirement. He raises the really important question, putting it very broadly, is, I suppose, is arbitration fit for purpose? It had nothing to do really with the case, and whether he should have said what he said is uncertain. We have one of His Majesty's Justices here, at least one today, and he may have a comment on that. But he talks about the importance of looking at arbitration, and it deserves our attention. I suppose that's right. But then he says, the risk is, and I'm quoting from paragraph 583, the risk is that arbitration as a process becomes less reliable, less able to find difficult but important new legal ground, and more vulnerable to fraud. So basically, he is suggesting, or raising the question anyway, whether arbitration is fit for purpose or not because of those three risks. So, is it less reliable? Is it less able to find difficult but important new legal ground? And is it more vulnerable to fraud? And those are the three main points that I think come out of this judgment that he raises, which are of huge importance. So far as the first becomes less reliable, the question is, what do you mean by reliable? Michael Mustel, I remember doing my first case, it's an old story, but if you haven't heard it, you heard it now for the first time. Some of you may have heard it. I run up to Michael Mustel having won my first case. And he said, fantastic, he says, that's great. He says, but I've lost every case I've done in the last 4 years, he said. But he said to me, when you go to arbitration, you buy the right to get the wrong answer. And he was very serious about that, very serious about that. The whole point about arbitration is that it should be less reliable, less predictable than going to court. Now, whether that's right or not, maybe we'll take a vote as to what that should be at the end. So that's the less reliable point. Less able to find difficult but important new ground. Now, that's a hobby horse of mine. and also Mr. Justice Baker, who is here today. The question that I would pose, and I gave a speech about this in Dubai, is, are arbitrators bound by, I'm going to say, the law? I put it very, very gently. That encompasses a whole range of questions. Are arbitrators bound by a decision of the High Court? Are arbitrators bound by a decision of the Court of Appeal, House of Lords, or possibly Privy Council? And I stand on the shoulders of great people, but one of them is Mr. Justice Baker, who gave a fantastic speech in Vancouver in, I think, 2012 at the ICMA conference, where he came to the conclusion that, I hope I summarize it correctly, that certainly arbitrators are not bound by a decision of a judge of the High Court, and it may go further. I went further. I'm always a bit greedy, and my speech is in effect that arbitrators are not bound by any decision of the High Court, Court of Appeal, or Supreme Court. And if you say they are bound, what do you mean by bound? Where subject to Section 69, there's no remedy. But that's the second point. The third one is more vulnerable to fraud. Is it right that the arbitral process is more vulnerable to fraud? And I'm not sure that it is. I think it ultimately all depends upon the tribunal. In the arbitration in the judgment in the Robin Knowles case, in fact, I think it was Lord Hoffman who was the chair, not Court of Appeal, but Lord Hoffman. Would he have come to a different decision if he had been sitting in the Chancery Division rather than sitting as an arbitrator? And I'm not sure you can draw that necessary conclusion at all. So Mr. Justice Robin Knowles makes those 3 points: less reliable, less able to find difficult but important new ground, and more vulnerable to fraud. Each of those raise rather interesting questions. So would anyone like to comment on this? Let's take less reliable, for example. Are arbitrators less reliable? Is that a good thing or a bad thing? I'm going to put Mr. Justice Baker on the spot. When you see the really important point, sitting as an arbitrator, as I do sometimes, and someone shows me a decision of Mr. Justice Baker or someone else that I think is completely wrong, what do I do? What do I do about that? Some of you may, I'm talking too much, but Robert.
Bernard, with respect, I think you're diverting what Mr. Justice Knowles said into standard issues about relations between the arbitrators and the law. Whereas I think one thing in particular about more vulnerable to fraud, Jamie said that it was a question of the instructions that the counsel were getting from Nigeria. But I think if you read the judgment, it's obvious that I forget whether it's liability or quantum that this happens, I think it's quantum, that the counsel who was then instructed by Nigeria, who was a Nigerian senior advocate, simply was visibly, completely incompetent. Now, one thing I know from experience is, as an LMAI arbitrator, if we get a case where the respondent just doesn't appear, we take great care going through the claimant's case to check that it is a complete prima facie case for the remedy that the claimant is seeking, including whether the documents in front of us support the claim, the quantum that the claimant is claiming. But in the case in question between Nigeria and P&ID, because Nigeria appeared and was represented, the arbitrators didn't do any of that. And I don't think it's particularly radical to say that if people appearing on behalf of the respondent are obviously completely incompetent, then the tribunal should do the same as it would do if the case were undefended.
My problem with that, Robert, is that you may be right. I say nothing at all about the particular case, but it's not often that an advocate on one side is completely incompetent. The real problem, when I see it, is that there are grey areas where a particular line of argument, a particular pleading misses a big point. What do you do then? And if I may say so, that it happens regularly, but it happens with counsel. London Counsel will miss a point in a pleading. What does a tribunal, an arbitral tribunal, actually do in that case?
And I have to confess that I think I'm more interventionist than many LMAA arbitrators.
Right, let me put
But this was an extreme case. It's a case of complete incompetence.
I know, but I understand that, but I'm keen almost on the run-of-the-mill case that happens where, let me put it, I like votes. Let's assume otherwise competent counsel, you sit as an arbitrator and you see misses a point. Should the tribunal intervene and say, why don't you plead misrepresentation? Obvious point, why haven't you pleaded it? Okay, hands up who would say, I will tell counsel that they should, or suggest to it. No one. There you are. So Robert Gay. I mean, I did a case in the Court of Appeal, I'm going to say 40 years ago, where I was terrified that the other side would raise a point that was obviously right, and never did in the Court of Appeal, and we won. Now, one of the questions is, what should counsel do in that? Should counsel go, oh, the other side's got a particularly good point, a legal point? What should you do? Should you alert the court to that? Do you have a duty to do that? But what about a tribunal who sees that a point that hasn't been raised? I'm afraid, Robert, you're on your own on that. But sitting as a criminal judge, which I used to do, where a point wasn't raised or was not put, I certainly did intervene then, particularly where the defense counsel had not put a point in cross-examination or whatever. That I think there is no doubt at all. At the back. Yes, sir.
Hello. Well, it's loud. Jide Adeshokon, Stevenson Howard. We had some involvement in the P&ID case, as Jamie's aware, at the very start in the first attempt by Nigeria to set aside the award. I have to say I agree with Robert because we followed the case throughout from beginning to end. I think to a certain extent it's a question of degree. There is a point at which things are so glaringly bad that I think it lies upon the tribunal. And this is one classic case where the discount rate, for example, of so the metrics by which the likelihood that a project would succeed, the tribunal effectively accepted that the likelihood of a project succeeding was the same in Nigeria as it would have been in Western US or in the UK. That's effectively what happened. That's so glaringly wrong that I think even if and I wouldn't go as far, even though I agree with Robert, I wouldn't go as far as to say that the Nigerian lawyer was incompetent, because he did have his finger on the pulse. He completely had his finger on the pulse, but was not, but did not understand the intricacies of arguments on quantum. And so neither did their expert. But where you're effectively agreeing to such disparities of quantum, I think it does lie on the tribunal to a certain extent. And I think also, I mean, Sir Bernard, you tell me what you think, but I think courts, high court judges have more confidence, I think, in probing, in allowing the other side to find their way to the answer in a way that tribunals might not be able to, just for any fear that they will be challenged. I think that's the risk, and that's the fear that people have.
Well, let me ask another go. Who thinks arbitration is too cozy? And I can't hear Nicola.
But like a lot of things we've been saying, coziness is in the eye of the beholder. So what is cozy to one party is being commercial to another. So it is all a question of degree and advanced standards. which stance to take.
Not too cozy. I think the non-cozies have it. I did an arbitration where I thought the expert on one side had not disclosed, had not looked at particular documents, and I cross-examined him, I think, and my co-arbitrators at the break got very, very angry with me and told me that I had overstepped the mark, and that we should leave cross-examination to the counsel on the other side. And I felt, I'm not sure, I thought I was acting quite properly, but the case settled overnight. The case settled overnight, and is that good or not good? But the expert crumbled, didn't come back the next day. So I do think arbitration is too cozy myself. I think I'm not sure I would go so far as Robert, but I do think that it should be. I mean, one talks about the commercial court being robust, and maybe arbitrators should be more robust.
Is that what you mean by reliable? When you talked about reliability, do you mean it should be more unpredictable, or do you mean?
I'm not here to say one thing or another, but I think there is a strong view that Michael Mustall was right, in the sense you go to arbitration, you buy the right to get the wrong decision. You get the wrong decision, can you do anything about it? And the short answer is you can't, unless you can get within Section 69. And there's obviously an important balance there between finality and justice. Any number of cases, I'm afraid, I won as counsel that I'm not sure I should never have won, but it was certainly arguable that they should have gone to court, didn't go to court, and equally a number of cases that I lost, which I should have won. And that's, Nicola, is in the eye of the beholder, I should say. All the cases I lost were completely wrong, and the ones I won were completely right. But I'm talking too much. Yes. Microphone.
No, what I was going to say that in my limited experience, because I haven't had many arbitrations recently, arbitrators tend to make more moral decisions rather than follow the law. I want, if I go to arbitration, to make sure that the law is followed. If the arbitrators will make commercial decisions, have more sympathy to one party and all the rest, then I think that's not a good way of dealing with disputes.
Well, that's a provocative comment. Anyone disagree with that? Anyone? No one disagrees with it.
Well,
everyone agrees with that.
Well, there is another word for just moral, which is commercially reasonable. I mean, it's a trade-off in a way, in that if you go to arbitration, you're buying less chance of getting an answer that is right as a matter of law, but you're getting the chance of having the dispute determined by people who know the business better, as distinct from a single judge whose education is as a barrister. And there are all sorts of things that people in the market know without being told, and barristers only know if you produce an expert who says it.
I disagree with that violently, but I'm not going to. And what I'd say, Robert, to you on that is that the arbitrators will decide things according to their own perception of what may be reasonable. And I'm not sure that when you say commercially reasonable, I think that's, I don't think I would disagree with that. It introduces an element of subjectivity into that. Yes.
I've primarily been involved in disputes as an expert, and there's two sort of things really. Firstly, I have seen cases where it's been badly put together, and sometimes an expert, you can only answer what you've been put in front of. But I think generally, when arbitrators get involved and ask question of the expert, the outcomes tend to be, it's quite a good process. And I was sort of on that side of the fence, would recommend that as a good procedure. And you were mentioning about you saw something missing from the other expert, and I think that's fine. But I think introducing and perhaps changing what's been put forward is perhaps, where does it end? Where does it start? So takeaway point is, I think arbitrators asking question of the expert, I would always think is a good idea.
We are mostly comfortable, except in very rare circumstances when particular doctrines apply, to say when parties have negotiated and concluded a deal that they get what they've bargained for and agreed. And if one party was far more sophisticated, clever, well-resourced in their negotiating team, and as a result get a better result in their contract, good for them. I say provocatively, if they, as part of doing so, then agree an essentially contractual, private, commercial system for resolving their disputes, why should it be any different? If one of them then has the commercial power within the relationship to be better resourced and provide a better legal team that does a better job, why shouldn't they win? If, broadly speaking, the putting of the case better is more persuasive, why is it then the tribunal's job to improve the bargaining position of the weaker bargaining party in that particular commercial process? I don't necessarily believe that, but I thought I'd put it forward as a provocative thought.
Presumably, procure the better contract by bribing the other side.
Anyone disagree with that? Or have to stop in a minute or two. Anyone else would like to join the fray? I mean, the debate between finality and justice and the process goes back forever, and I rather suspect will continue forever.
I think there's one point as well, is the party's choice of an arbitrator. And that can have a huge impact, whether it's a technical dispute and you have a single arbitrator as a technician, or you have a very legal dispute, you might have a KC or a retired judge. And that will, I think, to give parties the power to choose that, in essence, gives them quite a wide choice as what type of arbitration they want. So arbitration, it can be, again, the eye of the beholder, who you have as the tribunal. I think that's very powerful.
So, Bernard, I did want on one other point, if only because Robert raised it, and these days I'm the Admiralty judge, so I theoretically ought to know the answer, or at least I ought to know what I think the answer is, subject to considering carefully any contrary submission if it arises. Robert raises, supposedly as an example of something that would be partially sent off to arbitration, a tonnage limitation case in which somebody wishes to say Article 4, no right to limit, and the answer is that can't be arbitrated if the proposal is to have that decided in rem. Only the Admiralty Court is going to be able to decide that in rem, so as to bind all potential claimants to the limitation fund. By contrast, however, when it then comes to the establishing of the liability of the limiting parties, the underlying original liability of the limiting parties to the claimants against the fund, routinely, at least at the moment, we do then stay that. Equally, relatively routinely, we find parties saying, well, if we're conveniently going to sit alongside other people with similar claims, we'll waive arbitration and get it all dealt with in court. But that's a separate commercial choice. But it seems to be at least subject to considering submissions if they come up in another case, that if what someone is trying to do is get a ruling intending it to be binding in rem against all comers, then arbitrators by definition are not able to do that. And so that has to stay in court.
Right, well, thank you all for coming, and thank you to my speakers.